WAUK.
And good morning. It is Saturday, January 27th, 2024. My name is Jim Santelle, and I'll be your host for the next 2 hours on our Saturday morning broadcast. I'm delighted to have you joining me this morning as we pursue, as always, our morning review, our analysis, and our discussion of some of those most significant, impactful news events and developments in the areas of what? Of law and government, and the aspiration for justice in America. As always, I'm supported and assisted by a wonderful producer. This morning, Johnny is in the studios with me here at WAUK Radio in downtown Waukesha. And together, we're going to bring you 2 hours of analysis, review, consideration of those significant stories in those areas, focusing this morning on, as always, an ambitious but achievable agenda. I'm going to talk with you about that in just a moment or so. And as always, in connection with our agenda, our syllabus, our academic review this morning, we asked 3 principal questions. We asked, first of all, what happened? A lot of focus on that this morning. We're going to talk about what we know. What are the facts? What actually do we know based upon the events of recent days and recent weeks? Second, we always ask here on our Saturday morning broadcast, why are those things important? Why are they significant? It is one thing, of course, to understand the news. Why are they important to understanding the world in which we live, our state, our locality, our nation, beyond the simple fact of the news itself? Why are those things relevant? Why are they material or significant in our lives? We answer that question as well. And finally, a third question, not always answered, but often applicable to understanding what happened, and then why are those news stories important? And that is, what should we do in the exercise of our own independent individual discretion? How should we respond? What are the actions and responses, the answers we should give to those things, again, in the exercise of our rights as Americans, as people on the face of this planet? What are the kinds of options that are out there in response to those things that have happened during the course of our days, our weeks, and our months? As always, delighted to have you joining me here on the broadcast stations of Civic Media throughout the great state of Wisconsin. And I know there are listeners out there beyond the state of Wisconsin. Appreciate your participation as well in our discussion this morning of all of these major issues. And what are those issues this morning? Let me give you some sense about where we're going to be going this hour, and then in our second hour here on our Saturday morning broadcast. Courts. I have notes, as always, this morning, and I was writing just before talking with Johnny about our show this morning, noting it's all about courts this morning, as it often is. A lot of focus on the United States Supreme Court, other federal courts, but we're going to begin with an international court. Some major news, somewhat in the national media and our local media recently, but somewhat overcome by other stories in other courts that have in some ways eclipsed the story coming out of The Hague. And yes, we're going to talk about a major case that we have talked about before, this prosecution by South Africa against Israel, alleging genocide in connection with the Israel-Hamas war. We're going to talk about an interim decision made by the Court of International Justice. What did they say? What didn't they say? What is the schedule for their timetable about resolving this lawsuit brought there in the International Court? The Hague is going to start our discussion this morning of courts in our planet, across the seas, and significantly affecting, of course, us right here in the United States of America. Then coming back to our nation, some of the major news breaking just yesterday: a jury in the federal district court in New York finding that Donald Trump is now responsible to pay E. Jean Carroll for defamation, amount of about $83.3 million. We're going to break that down. We're going to talk about what the jury did, a little bit more about what happened just this past week in the presentation of the case about damages based upon the allegations proven now at least twice, if not more, by E. Jean Carroll, defamation by the former president, Donald Trump. What happened yesterday in the federal district court? There's going to have implications for the future as well. Then we're going to turn to some other cases also involving Donald Trump and other individuals. We're going to go back to the D.C. Court of Appeals, talk about what's pending there, the gag order, the so-called order previously imposed by a district court judge in the District of Columbia trial court, requiring him not to talk about certain things outside of the confines of the court. And we're going to talk about what the circuit court did just this past week. And yes, indeed, what it has not yet done. What it has not yet done in connection with the all-important immunity issue that Donald Trump and his attorneys have raised, also in defense against the federal criminal lawsuit being brought by the Department of Justice and Jack Smith, the special counsel. We'll talk all about the District of Columbia Circuit Court, what it has and has not yet done, perhaps imminently going to decide that case on immunity. Then we're going to also chat about the Colorado case. What happened just this past week? Well, the parties on behalf of the state of Colorado, the people who brought this case on behalf of the folks in the state of Colorado, filed their brief with the United States Supreme Court. You may recall that in previous broadcasts, we have talked about the brief, the written submission made by Donald Trump and his attorney, asking the United States Supreme Court to overturn, to reverse the decision made by the Colorado Supreme Court that, at least for now, keeps him off of the Republican primary ballot in that state. Just this past week, some significant events having to do with what the proponents of the decision to keep him off that ballot have said to the Supreme Court in writing. And then we're also going to talk about what's happening in Maine, the state of Maine, a collateral issue out there, also dependent upon what the Supreme Court may do in connection with that Colorado decision. It sounds like a lot, I know. It actually isn't. And we're going to parse all of that out and talk with you this morning about those Colorado and Maine situations, also pending again before the United States Supreme Court. We need to mention, again, as I always do, this third case that's also pending in the United States Supreme Court. It's a case called Fisher. And Donald Trump's name isn't on it, but it has the potential, depending upon what the United States Supreme Court does in this Fisher case, has the potential to have a great impact upon the criminal prosecution, again, of Donald Trump in that singular indictment against him pending in the District of Columbia trial court. 4 counts there being prosecuted by Jack Smith. All of those cases in and out of the federal courts, Supreme Court, the D.C. Circuit Court, the D.C. Trial Court. All of those cases we're going to talk about this morning. And then, principally in our second hour, as a part of our continuing syllabus here on the broadcast stations of Civic Media, we're going to turn to a very important but seemingly dark and often grisly topic, and that is the death penalty in America. We're going to talk about the Eighth Amendment, that prohibits cruel and unusual punishment. What does that mean in America? In the past week to 2 weeks alone, 3 major cases, 3 major instances where issues related to the imposition of the death penalty in America have come into the news, come into the focus of all of us here in our nation. One of those cases coming out of Alabama, something happened just on Wednesday and Thursday of this past week. We're going to talk about that. We're going to talk about another case in Oklahoma, again involving the United States Supreme Court, a decision that it has made to review a death penalty imposition, a judgment imposing the death penalty. We're going to chat about that as well. And then we're going to talk about a decision and the process by which the Attorney General of the United States of America has recently made the decision to seek the death penalty, to petition the court, petition the jury, petition the court in that case involving the Buffalo shooter, that horrific hate crime, that racist shooting in Buffalo. The decision by the Attorney General just in the past couple of weeks to seek the imposition of the death penalty. I'm going to give you some sense of why that is rare in this administration. And even before addressing all of those death penalty items in the news these days, we're going to spend some time, as we sometimes do on our Saturday morning broadcast, talking about the issue more broadly. We're going to tell you a little bit more about what the Supreme Court has said in connection with the legitimacy, the constitutionality of the United States Supreme Court's decisions when it comes to the death penalty. They have ruled in a number of cases and affirmed as late as recent years that the imposition of the death penalty in and of itself is not a violation of the Eighth Amendment, the prohibition there in our Constitution of cruel and unusual punishment, but have imposed under the Eighth Amendment a number of requirements, some standards, some practices that need to be followed if states, in their discretion, in their decision-making process, determine to seek the death penalty and impose the death penalty. The Supreme Court has given states instruction on what they can and cannot do when it comes to the process that will lead up to the execution of an identified defendant, and also the terms and conditions by which individuals in America are in the end executed. We'll talk about some of the cases going way back to the 1970s, bringing you current to recent cases again in the news just this past week, just the past couple of days. The death penalty, plainly not a subject of great attention during this presidential year, this presidential campaign year, 2024, but based upon the increasing focus of the Supreme Court and certainly of other states that do have the discretion under the Constitution as interpreted, they do have the discretion to impose the death penalty if they should choose to do so. We're going to talk about the increasing focus of death penalty prosecutions, the implications of that not only for the campaign now underway, but the possibility that we are entering into a new era in our recent contemporary American history in which death penalty issues once again, like many other issues in our national experience, become a part of our appropriate discussion. This is one of those areas. It is grisly. It is dark. And I want to tell you that we're going to be spending some time even talking about this Alabama case that is not for the faint of heart. Because of course, this is the ultimate thing. This is the ultimate thing that a government can do. I have often commented in my role, not only as previously as a federal prosecutor, that the single most significant thing that a government can do is deprive you of your liberty, right? Some people say it's the imposition of taxes. Well, the reality is that imposing a judgment that restricts your liberty even greater, and certainly within that category, the imposition of a death penalty judgment, that is the single most important thing that a government, a state can do, a significant thing that it can do. I'm going to talk about the implications of all of that this morning, appropriate for our discussion here on our Saturday morning broadcast. As always, we invite your close listening to this, your close attention to what we're talking about. Courts in America, courts overseas, in our federal courts, our state courts, how they impact the things that we are thinking about in 2024 and beyond, and focusing on all of that in a rule of law syllabus, a rule of law prism that once again focuses on the administration of justice, government, and the delivery of rule of law principles in our courts. Stay with us after this first break for that discussion. And we're back. We're back after that first break in our Saturday morning broadcast. Thank you for joining me once again as we undertake this morning to talk about many issues related to decisions made by courts and indeed juries in courts in this country. We're going to begin, however, by going overseas to the Netherlands. We're going to talk about this major decision coming out of The Hague. What is the story here, and why is this important to understanding the world in which we live? We all know at the top of the headlines these days, two major, not the exclusive wars on the face of our planet, but two major wars, one of them plainly in Ukraine, the war involving the invasion of Russia into the Ukrainian democracy, into the Ukrainian nation. That war still going on. And the other significant issue, of course, the Israel-Hamas war that continues to rage. A lot of focus on that here in our nation, not only because of our connections to Ukraine and certainly our adversarial relationship with Russia, but also when it comes to the Middle East, our long-standing alliance and our partnership with Israel, and our support along the way for a Palestinian nation as well. Our government has advocated and continues to advocate for a two-state solution to the problems that continue to plague the Middle East. All of that, the setting just this past week, just yesterday, for a major decision coming out of the United Nations highest court on Friday, saying just this, saying that Israel, the state of Israel, must take action, directing the state of Israel to take action to prevent acts of genocide by its forces that, as you all well know, are now in Gaza waging that war against Hamas. The High Court That is the International Court of Justice, sometimes referred to as the ICJ, sometimes referred to simply as the Court in The Hague. This is, of course, a major, major decision coming in the wake of the decision by the South African nation. We have talked about this before on our Saturday morning broadcast. The decision by the South African nation, South Africa, to prosecute its case in the International Court of Justice against Israel, alleging very broadly, but with some specificity in their complaint, that Israel has engaged in genocide, a charge that the Israeli officials have denied and rebuffed with great, great animosity and great force in the course of the prosecution of that case before The Hague. Again, just yesterday, this high court saying that Israel obliged to take action to prevent acts of genocide to the extent those are happening by its forces in Gaza, and must also, this again coming out of the high court, Israel must also let more aid into Gaza to address the human rights concerns there. Significantly, this decision coming out of the United Nations highest court did not call on Israel to immediately suspend its military campaign, to pursue, if you will, that ceasefire advocacy that is out there both in our nation and in other places around the world. Again, this ruling by the International Court of Justice, an initial step in a case brought in that international court by South Africa accusing Israel of committing genocide against Palestinians in Gaza. Significantly, the court itself, frankly, like most courts, really has no enforcement mechanism aside from the force of its language and the significance of its word. But nonetheless, this sort of judgment, this sort of preliminary judgment, which we will get to, this initial decision by the High Court, the UN High Court, did spawn an awful lot of reaction on both sides of this dispute, as you can well imagine. Initial reaction among Palestinians was apparently, and still coming out, of course, it just happened yesterday, was decidedly mixed. Palestinian foreign ministry saying that the court had, and these are its specific words, had ruled in favor of humanity and international law. That's the Palestinian foreign ministry responding to The Hague's decision. But others saying that the judges are appropriately criticized, for not ordering an out-and-out stop to the war in Gaza. Israel, not surprisingly, which again had defended strongly against this lawsuit throughout its recent prosecution there in the ICJ, strongly has denied the genocide charges. On Friday, its officials lashed out at the court. Benjamin Netanyahu, as you know, is the prime minister of Israel, said it was outrageous, that is his word, for the judges even to hear this case. And there's a defense minister, his name is Yoav Gallant, and Mr. Gallant actually was quoted with some focus and some primacy during the course of this trial because it's some of his words that allegedly, according to South Africa, constituted some incitement to genocide. So much of what he had to say, the defense minister Gallant, was a part of the trial itself. Gallant, in response to the decision by the ICJ, said his country did not need to be, as he said, lectured on morality. A packed courtroom throughout this past month. Lawyers for South Africa arguing that Israel had meant to create conditions of death in Gaza, and had demanded as a part of their petition, their prosecution, that the court order an emergency suspension of the military campaign. Again, the High Court did not do that second portion, but they did. They did say that Israel must take, according to their decision-making, every possible action to prevent further acts of genocide by its forces in Gaza, and also supporting the notion that more aid needs to come into the Gaza enclave. A 29-page interim ruling. Why is that significant? Because this is not the final word. This is not the final word from the International Court of Justice in The Hague. The 29-page interim ruling said that Israel must take these actions to ensure that its soldiers and citizens adhere to what's called the United Nations Genocide Convention. Very broadly, that prohibits, of course, genocide in the conduct of any war. This UN Genocide Convention all the members of the United Nations bound by doing that. The 29-page interim ruling, this preliminary decision by the court, also says to all the parties that they are required to report back in a month to show how the parties, and in particular how Israel, is complying with the instructions given in this order announced just yesterday. Now, why is that significant? Why is this preliminary or, again, an interim ruling? Because the court itself, on the ultimate request, which is to direct that the hostilities there in Gaza immediately be suspended, probably, as we've reported and commented upon previously in this broadcast, the final decision probably not coming for, yes, that's right, years down the road. A lot more to do here, but an interim report, this interim order coming out of the ICJ just yesterday. So what does it mean? What does it mean in terms of practical reality? Well, it does mean that South Africa won its initial application. It had applied under this process called provisional measures, which are sort of roughly equivalent to a temporary injunction in our judicial system. That is a directive that a court will enter to preliminary direct that a party not engage or engage in some conduct. And again, these proactive steps coming out of the ICJ to ensure that genocide doesn't occur in the future while this broader case is still pending. Much beyond that, of course, a lot of this having to do with the political implications of it. This final decision on the ultimate question, years yet away, and South Africa's partial victory, not yet viewed as a sign of what the court may do in the future. We'll continue to operate to focus on all of this in the future. A major case in the rule of law internationally just this past week, just yesterday, coming out of the International Court of Justice in The Hague. When we come back, we're going to come back to courts here in the United States of America, including a federal district court in New York City. Stay with us for that discussion. And we are back here on our Saturday morning broadcast. Thank you for once again joining me. We have spent the first moments of our Saturday morning broadcast talking all about this major decision coming out of the International Court of Justice, The Hague, and finding that although Israel has not necessarily committed genocide in this preliminary order, nonetheless, the court ordering that Israel take all available steps to prevent genocide in the future by its forces in Gaza, and also permitting more aid to enter into the Gaza territory. A final decision, as I said before the break, not happening probably for years on that ultimate question about whether or not Israel has in fact committed genocide or is in fact doing so. The requirements for winning a genocide case on the merits much more difficult than they are at this present stage to meet the lower threshold for these so-called provisional measures, which is the process that the South African government has invoked as a part of its present prosecution. Now, there is some precedent. There is some precedent for the court ordering an immediate ceasefire. I suspect you can figure out what that was. It did so in 2022, less than a couple of years ago, after Ukraine brought a case similar to the one pending now that is the subject of this interim ruling. Ukraine brought a case against what country? Against Russia, right? Under the UN Genocide Convention. That case, of course, very different. One sovereign state using force to take over another, as Russia has tried to do, continues to this day to try to do, is one, of course, of international law's most significant prohibitions. By contrast, this one is much more unclear before the court. After yesterday's decision was announced, commentators speculated that the court has a lot of work to do yet in resolving that ultimate question. Again, probably not going to be hearing from the court again for a couple of years, even though the parties again obliged to come back to the court within about a month to advise what those nations, in particular Israel, has done to comply. All of this, again, raising an issue about compliance. What is the enforcement capacity of any court? Plainly, the International Court of Justice does not have an army. It plainly does not have enforcement powers, but the strength of its words are compelling, and that's the story. That's the rule of law story coming out of the Netherlands just yesterday. Coming out of a federal district court just yesterday as well, a major jury verdict, and you have heard about it a lot in the media, including right here on the news feeds of civic media as late as just a few moments ago. Former President Donald Trump, again embroiled in this continuing years-long litigation brought by E. Jean Carroll, a writer, a person who has provided articles and otherwise some advice columns, a national figure in many ways. Bringing this lawsuit has a number of different incarnations. One of them alleging, as she has in this federal case pending in the district court in Manhattan, that Donald Trump, when he was the president of the United States of America coming out of the Oval Office, defamed her in denying her allegations, which he had written about and also spoken about, that he had engaged in sexual assault of her in a Bergdorf Goodman store in the 1990s in Manhattan. She has effectively proven that already. And those issues, the subject of previous litigation, also in the courts of our country, also in this Manhattan courtroom, that issue already decided. That is whether or not the sexual assault, the rape, actually happened. A proceeding has determined as a matter of fact and now as a matter of law that event occurred. And so what is this present case all about? This case all about what judgment should be entered based upon that initial factual finding. What is the amount of what we call damages? What is the amount of money that will compensate the plaintiff here, E. Jean Carroll, for the harm done her by virtue of this defamation, which has been proven and established in a court? Now, that's not to say that Donald Trump, as we'll hear again in just a moment or so, has not denied that. But the fact of the matter is that we have a system of laws in this country, rule of law, justice, government. We talk about all of those things during the course of our broadcasts here on Saturday morning. And in this particular instance, that particular judgment already entered about the underlying facts. And so what happened just yesterday, just Friday afternoon, a jury deliberating for probably no more than about 3 hours, not a lot of time, but plainly decisively based upon the evidence that it has heard in this past week, principally, but not exclusively, from E. Jean Carroll, about the amount of money that will compensate her for the damages done by virtue of the defamation that Donald Trump has engaged in. The jury, as you well know, requiring Donald Trump to pay $83.3 million, yes, that's right, million with an M, to writer E. Jean Carroll for defaming her in 2019 when he was the president of the United States of America. Also attacks he's continued in social media posts, at these news conferences along the way, and significantly, even in the midst of the trial of this past week, during breaks, while the trial is going on, he continues to post things on Truth Social, his own social media platform, likewise continuing to defame her. And interestingly, in a case that, again, may not be unprecedented, but pretty darn close, Roberta Kaplan, who is representing E. Jean Carroll, using the things that Donald Trump is posting quite literally in real time during the course of the very presentation, the very trial that's going on. While he is doing that, she is assembling that evidence and providing it to the jury in further support of the request that E. Jean Carroll made for about $10 million for compensation for what? To restore her reputation, to put her back in a situation, or at least try to put her back in a status where she can claim some legitimacy and perhaps get on with her life, both in terms of her own personal life, her social life, and specifically her business life, so much impacted by this defamation. In fact, her lawyers had argued that a large award was necessary to stop Donald Trump from continuing these attacks on her, which have not gone unabated during the time that this case and other cases have been pending. 3 hours of deliberation, as I just said, the jury responding by awarding $65 million in punitive damages inside that $83.3 million amount. Now, where does that come from? Well, our concept of punitive damages comes from that word punishment, right? we've talked about this before in other settings. What is the amount of money? What is the amount of money that will be imposed upon a defendant, in this case Donald Trump, that will, yes, that's right, punish him for doing what he has been doing, but most significantly will deter him? Another word we have used a lot on this broadcast, deter him from engaging in this conduct in the future. What is that amount of money that will stop him, keep him from acting in the same way as he has done in the past? On one recent day, for example, Donald Trump made more than 40 derisive posts about E. Jean Carroll on his own Truth Social website. Again, a part of the evidence presented during the trial of this past week. Significantly, Donald Trump himself left the courtroom for the day when the judge, his name is Lewis Kaplan, he is not related to the attorney representing E. Jean Carroll, called in the 9-member jury shortly after 4:30, warning the lawyers that we will have no outbursts. That's what the judge had said as this jury is coming back with its verdict. Verdict delivered 9 minutes later to utter silence in the courtroom. So the judge's admonition to everyone there not to engage in any sort of outbursts. This $65 million amount, plainly a result of deliberation by the jury. We don't know exactly how they came to that specific amount, but plainly a determination by this jury that is the amount that is needed simply to punish for this behavior. And in an attempt to try to keep him from doing this in the future, the imposition of that as a civil judgment. Again, important to underscore, unlike many of the other cases out there, this is not a criminal prosecution. This is a civil prosecution where the plaintiff, E. Jean Carroll, has the burden of proof by a preponderance, basically 51%. More evidence, just over the edge, if you will, 51% of evidence, a preponderance of evidence to prove her case. She did that on the underlying facts of the case and now has done it with respect to certainly both components of this $83.3 million judgment entered just yesterday. In addition to this $65 million amount, which is now a part of the judgment against Donald Trump, those same jurors were awarded Ms. Carroll $18.3 million in compensatory damages for her suffering, as she alleged during the course of this trial. What is that all about? Compensatory damages, compensating someone for the harms done to them, and establishing this amount based upon some specific evidence. What was that evidence of this past week presented by E. Jean Carroll and Roberta Kaplan, her lawyer? The evidence brought in about the opportunities, the business opportunities that she has lost, the shutdown of many of her opportunities to continue to publish, to write, to do the kinds of things that she has done as an active and productive member of our society, but also somebody who has a reputation out there. All of these business opportunities lost, and also the amount of money needed to return her to that position where she can continue to get those kinds of business opportunities in the future. That's the compensatory damage portion of this, $18.3 million based upon what was presented during the course of the trial. Over and above that is the $65 million amount that's in the punitive damages, and that's how you get to the $83.3 million judgment overall imposed by this jury. What did E. Jean Carroll say after the return of this verdict? She said, "This is a great victory for every woman who stands up when she's been knocked down, and a huge defeat for every bully who has tried to keep a woman down." Now, Donald Trump himself, as I indicated, walked out of the courtroom earlier during the closing argument by Roberta Kaplan, E. Jean Carroll's lawyer, in a Truth Social post afterwards, said that the verdict was, in his words, absolutely ridiculous, not surprising given what he has said in the past. He said this, he said, "Our legal system is out of control and being used as a political weapon, capital P, capital W." And he pledged to appeal, as did his attorney right after the return of this judgment. He said they have taken away all First Amendment rights. Again, all of that posted by Donald Trump, none of that real, none of that legitimate, none of that based upon what actually happened here. He did, in fact, have an opportunity to defend against this case on the underlying charge of the sexual assault that now we know took place based upon the evidence presented in the mid-1990s in this department store in downtown Manhattan. And yes, indeed, he also had this opportunity afforded him in the due process, in the rule of law system, which is our court system, to push back on this claim for compensatory and punitive damages. As we know, he took the stand probably for about 3.5 minutes, just the day before the jury returned with its verdict. Some very brief questions by his attorney about whether or not he intended the results of what he had to say. He said, no, I intended simply to protect myself, my family, and protect the presidency. Significantly, in cross-examination, a one-sentence cross-examination, the attorney for E. Jean Carroll asked him whether or not he had appeared at the prior trial, again suggesting that his focus simply on the money and not on the merits of this case. Cross-examination, direct examination, taking well under 5 minutes. He was afforded his opportunity to come forward, and what should have been done in connection with this particular prosecution, this particular portion of the case, this was once again about money damages. And so the relevant testimony, which again Judge Lewis Kaplan had said, we're focusing on that. He had restricted Donald Trump not to go off on one of his typical tirades, to focus his commentary, his testimony to things that are relevant. The relevant issue, damages, money. And so one of the things he could have testified about, which he did not do, is the amount of money that he does in fact owe and own right now, his properties, those kinds of things. Chose not to do that, and instead talked simply about the intent that he had in making these statements and the things that happened following those statements themselves. Again, Judge Kaplan presiding over both trials, ruling initially that the jury's findings about the sexual assault continued in this trial. The imposition of this major judgment yesterday continues to animate our headlines in America. When we come back, we're going to talk a bit more about that, and then we're going to move on to some other cases involving Donald Trump in the courts, the federal courts of our nation, including the D.C. Court of Appeals, and yes, that's right, the United States Supreme Court itself, also looking at Donald Trump in his litigation practices and cases. Stay with us for that discussion. And we are back here on our Saturday morning broadcast. Thank you for your continuing attention and focus as we talk about these cases pending in the international court and now back in the United States of America in our federal district court in Manhattan, talking about this major judgment entered against Donald Trump, $83.3 million by a jury, not a judge, not an administrative actor, not the president, no one else, but a jury looking at the evidence and determining that that is the amount to compensate the plaintiff for the injuries she suffered at the hands of Donald Trump, and also the amount of money to punish him, to try to keep him from doing this again. So one of the major questions, of course, as I indicated, about this case in its present focus is money. And again, Donald Trump deciding not to talk about his own net worth, although Roberta Kaplan talking about that, identifying some of the major properties that he has out there, and offering the jury some guideposts for what it can do in terms of that punitive damages amount, noting the value of Mar-a-Lago, noting the value of the former post office hotel that he held in Washington, D.C., the other assets that he's got out there. And again, the testimony from Donald Trump not focusing on his own net worth, which could have been relevant, prompting again Judge Kaplan to restrict his testimony to things that are relevant. And indeed, Judge Kaplan having to cut off Donald Trump even during the course of the very limited, minutes-long testimony that he provided. So in the wake of that, what happens next? Well, Donald Trump, through his attorneys, plainly committing to, promising to appeal, which they have the right to do. This, again, is in a federal district court in Manhattan. You appeal that then to the Second Circuit Court of Appeals. Interestingly, this case, again, coming out of something we've talked about at great length in the past, having to do with this prior decision, since overturned by the Department of Justice, a prior decision by the Department of Justice under the Trump administration, continued a bit under the Garland administration that found that these statements, these defamatory statements made by Donald Trump while he was the president, were things that he said in the course and conduct of his duties and responsibilities. An incredible finding by the Department of Justice, ultimately overturned internally by the Department of Justice, by the civil division there inside Main Justice, and permitting this case to go ahead against Donald Trump and not against any particular government entity, including the United States generally, finding that Donald Trump's statements were not things done by him during the course of his duties and responsibilities. Of course, they were not. And that initial decision, again, overturned that permitted all of this to happen. So the question now is, in the wake of this judgment, what happens next? Yes, certainly the appeal going forward. Predictably, that will take at least months, maybe even years before that judgment is rendered final. And what will happen in the meantime? Well, E. Jean Carroll, unlikely to get a check from Donald Trump anytime soon in that amount. But there are a couple of alternatives he does have before him. He can pay the $83.3 million to the court, which can hold the money while that appeal is pending. That's one option. And that is what he did last year when the jury ordered him to pay E. Jean Carroll $5 million, actually $5.5 million. You may remember that as well, in a related case. That a separate and distinct judgment, he actually paid that amount to the court even while that is up on appeal. The other alternative in the federal system, and many state systems as well, is he can secure what's called a bond, which will save him from paying the full amount up front, but that bond might require him to pay a deposit and offer some collateral to support the possibility, the option that he can pay this down the road, and certainly would come with some interest and fees. It would also require significantly Donald Trump to find a financial institution, a bank out there, a credit union out there, to be willing to lend him a large sum of money at a time when obviously he is in significant legal jeopardy, not just in these cases, but also in the criminal system as well. We know as well that beyond this particular civil case, this judgment, which now goes up in appeal, we will hear about it again as it is enforced, again, perhaps years down the road, but nonetheless, it remains a valid judgment for Ms. Carroll to collect against. The attorneys there are plainly going to be talking a lot about this in the future days. And they're also going to be talking about something else that's pending in New York, which we have chatted about a lot on this broadcast. And that is the continuing trial, the continuing processing, the continuing prosecution and defense of that major civil case again, brought by the Attorney General of the state of New York. Again, this one happening in a state civil courtroom. This is the courtroom overseen by Judge Arthur Engeron. We've talked a lot about that on this broadcast. Right now, what's the status of that case? That case is right now before the judge. He has promised that sometime at the end of this month, maybe into early part of February, he will render a decision. The Attorney General there seeking somewhere around $380 million in civil damages against Donald Trump in that case, based upon what? Based upon allegations of his violating state law when it comes to valuing properties that he owns. Again, in that case, much like this one involving E. Jean Carroll, there once again, the judge had previously found, as you may recall, that Donald Trump had engaged in the very fraud that the Attorney General had alleged. And so the recent activity, the recent focus of the trial, which we have chatted a lot about on this broadcast, all of the antics going on in that trial, including representations about the amounts of money that will compensate the state of New York for the valuation fraud that Donald Trump engaged in. All of that, we're still awaiting a decision from Judge Engeron, probably a lengthy decision, presumably coming out sometime this week, maybe next, sometime soon, joining this major judgment entered by the federal court in New York, probably very soon. Donald Trump's liabilities on the civil side of things continuing as these cases move forward. We will continue to monitor and watch all of that as well. I mentioned before, as we always do, that in addition to these civil cases, the E. Jean Carroll matter, the civil case alleging violations of state law in valuing properties, that brought by the state attorney general, those civil cases are parallel to the 4 criminal cases also going on. We're going to chat about those a little bit more right after this coming break. We're going to chat in particular about what's going on and what just happened this past week in the D.C. Court of Appeals, the Circuit Court having to do with this order previously imposed upon Donald Trump not to talk in many ways about what was going on. The D.C. Court of Appeals reaffirming an earlier judgment. And then we're going to talk about what the D.C. Court of Appeals still has on its docket. Yes, that's right. It's this major issue having to do with whether or not Donald Trump is immune from prosecution, criminal prosecution by virtue of his having been the president of the United States. A ridiculous, frivolous argument, but nonetheless, holding up all of this right now, still pending before the D.C. Court of Appeals. After that, we're going to talk about the Supreme Court, the Colorado case, and then this Fisher case as well, which will round out the next segment here in our Saturday morning broadcast. Courts, courts, courts. Lots of things going on in the courts of our land. Stay with us for all of that. And welcome back to the second hour of our Saturday morning broadcast. Thank you once again for joining me and my wonderful producer this morning, Johnny, for our discussion, our presentation, our review of things related to courts in America, and yes, indeed, courts overseas as well, focusing as always upon those major events, those news stories in the areas of law and justice and government in America. No exception in this, our second hour. We're going to begin our second hour by talking about cases pending right now in front of the D.C. Court of Appeals in the District of Columbia. This, again, is the mid-level appellate court above the trial court, but below the Supreme Court, this 3-part level of courts by which our federal systems work. We know well that the special counsel appointed by the Attorney General, his name is Jack Smith, that is a special counsel appointed by Attorney General Merrick Garland, has obtained from a federal grand jury a major indictment against Donald Trump, naming him as the singular defendant in a 4-count indictment based upon his alleged interference with the counting of the votes in the 2020 election. We've talked a lot about that in the past. Along the way, the judge assigned to hear that case, her name Tanya Chutkan, first imposed a so-called gag order. Again, as you know from our past commentary on this, not a big fan of that particular language, but that's the way the media and even sometimes the courts refer to it. It is actually not a gag order in the sense it doesn't prevent you from speaking completely, but it does restrict, as it would any other defendant in any other case, restricts a defendant from making statements in an extrajudicial capacity that would have an impact upon the legitimacy, the merits of the ultimate decisions being made by the district court. And so way back in October, Tanya Chutkan, the district court judge, restricted Donald Trump, again, based upon the statements made about what he has done in the past on Truth Social, things he's done on the campaign trail, from making public statements that were attacking witnesses and specific prosecutors or court staff members. Interestingly, she excluded herself from that in this case. In other words, telling Donald Trump, you cannot speak publicly out there about things related exactly to the things going on in the courtroom itself. You can't attack the witnesses. That is arguably a violation of the law in and of itself. You can't attack the special prosecutors or court staff members, things we have seen him do in other settings as well. And Donald Trump appealed that decision, saying, as he said once again in connection with the recent judgment entered against him by the jury in the E. Jean Carroll matter, he said that violated his First Amendment rights. Once again, it does not. It does not. The First Amendment, like every other amendment, every other right in America, is not unconditional. It comes with conditions. And when, as the judges have repeatedly said in this case and in other cases, that you are a defendant in a criminal case, you don't give up your First Amendment, but there are certain things that you need to understand and rules you need to follow to ensure the legitimacy of the very process that guarantees you as the defendant due process, equal protection, and the protections of the laws procedurally and substantively. Does not violate his First Amendment rights. Every defendant out there in federal court and state court obliged not to engage in witness tampering, not to engage in the kinds of attacks that suggest that the courts are not credible. That's what Tanya Chutkan was focused on. In December, just a few weeks ago, a 3-judge panel of the D.C. Court of Appeals, once again, the court above the trial court, above Tanya Chutkan, a 3-judge panel upheld that order, but actually narrowed its terms and allowed Donald Trump to keep attacking one of his main targets in all of these cases, and yes, that's right, Jack Smith. It excluded him from the ambit of the so-called restriction order. He, of course, once again, the special counsel prosecuting this case. And Donald Trump, in the wake of that 3-judge panel order, then appealed to what's called an en banc review, asking for en banc review by all 11 members of the Federal Appeals Court. They decided to grant that. They don't have to, but they decided to grant it. And indeed, just on Tuesday of this past week, that full panel of the D.C. Court of Appeals, all 11 judges, not just the 3-judge panel, reconvened, rejected Donald Trump's bid to lift that order imposed upon him in the criminal case in which, once again, he stands accused of trying to subvert the known results of the 2022 election. Now, what can happen next? Well, a couple of things. He can certainly appeal this further to the Supreme Court. One would hope that with all the other things that the Supreme Court has going on this docket and in previous dockets, future dockets as well, this is the kind of thing that the Supreme Court should say, you know what, we are not going to review this further. And in that case, it ends the matter. And Judge Chutkan then can enforce her order, even with the limited change, if you will, affecting Jack Smith that she previously entered. And it's entirely possible, hopeful, the Supreme Court will decide not to get embroiled in this particular sort of collateral issue. The other issue that's still pending before the same court, the D.C. Court of Appeals, again, before a 3-judge panel, one of the judges on the 11-judge panel, her name is Henderson, Karen Henderson. She is also a part of the 3-judge panel that's reviewing what? She's reviewing this decision also by Judge Chutkan on a substantive matter that's pending in that trial court. Judge Chutkan had previously found in an expansive, and I commend your reading of it, it basically reestablishes the fundamental trappings of our democracy, that we do not have kings in America. We've got presidents who are subject to the law, and that's what she said. And she went on to find explicitly, as many other courts have found, virtually all rational, reasonable commentators have on all sides of the political aisle, that no, a president is not completely immune from prosecution for crimes that he, maybe one day she, commits while in office. The idea of an executive or presidential immunity is frivolous, it is unfounded, and that's what she found. Now, Donald Trump, like appealing his so-called gag order to the appeals court, also appealed that order. And this case, obviously, more important because it goes to the substance as opposed to this sideshow about what Donald Trump can and cannot say. But as I have commented before and commented again this morning, this issue of whether or not a president of the United States of America is immune from prosecution, not subject to laws that 330 million other people in this nation are subject to, is ridiculous. It is fraudulent, it is frivolous, and it is arguably embarrassing even that we are spending time in our federal trial courts and now our appellate courts reviewing this very issue. Now, the Court of Appeals, this 3-judge panel, including Judge Karen Henderson, has had this case under advisement since January 9th. On January 9th, that 3-judge panel, as you recall, entertained argument by the attorneys, one attorney, obviously, for Donald Trump, also attorneys for the Department of Justice, arguing against, the Department of Justice attorneys arguing against the notion that this presidential immunity exists. Donald Trump's attorneys arguing for all sorts of policy reasons, not so much legal reasons, that it does in fact exist. And it was fairly clear, as we talked previously, that in the course of that oral argument, that the 3-judge panel was not buying what Donald Trump's attorneys had to position, had to argue in front of them on that setting. All 3 judges, in many ways, rejected the notion, proposing various hypotheticals that made clear that the notion that a president, a chief executive, is immune from prosecution is indeed a ridiculous notion. The concern, of course, that we all have is that that was January 9th. And we have now gone 2.5 weeks since the Court of Appeals has had that matter under advisement, has not yet issued its opinion. Again, in the category of what we hope for, we talked before about anticipation by Judge Engeron in that civil valuation case pending in the New York Manhattan case, that AG case pending upon valuations. He may issue his order sometime soon. We would also hope that very soon, tick-tock, that the Court of Appeals, this 3-judge panel, would issue its decision decisively stating, hopefully by a majority, a complete majority, a 3-judge majority, saying that immunity does not attach to a sitting president, and that this notion that Donald Trump has raised in defense of the allegation against him involving election interference, that defense is not valid, and that the case can then go ahead before Judge Chutkan. Now, what will happen in the wake of that decision? Predictably, a decision by at least 2, if not all 3 members of the 3-judge panel. Well, once again, Donald Trump could appeal that, could seek a writ of certiorari, as before, with the United States Supreme Court. And again, one would hope that the United States Supreme Court, on a case this clear, on a notion that is this clear, on a position where there is really no credible argument about immunities attaching to a presidency, you hope that the Supreme Court would say, you know what, we're denying, we're not going to grant that petition and turn this back. That would not only ensure that the case can then proceed, but it becomes then the law of the case, what the D.C. Court of Appeals will issue. That becomes the rule of law in this particular prosecution. It then enables Judge Chutkan once again to resume her oversight, her administration of this case. She has previously scheduled a March 4th trial date, a jury selection date on March 4th, coming up in just a few weeks. Plainly, she has suspended that while this, I will call it a legal sideshow, takes place to determine whether or not Donald Trump is immune. Every day that passes when the D.C. Court of Appeals withholds its ultimate opinion, this is not being overly critical of them. I suspect they're putting together a magnum opus on this issue of immunity that will stand the test of time, that will in fact convince the Supreme Court not to take this case, and I commend them for doing that. At the same time, it has been 2.5 weeks, and every day that passes is another day that the trial, this fundamental trial, the most important of the 4 criminal cases pending against Donald Trump right now, every day that this is postponed is a day that justice, whatever the verdict may be in that case, is also postponed. So once again, Donald Trump can in fact pursue an appeal. The hope is that the United States Supreme Court, as it can do in its discretion, does not grant this writ of certiorari, does not grant Donald Trump a review of that case, affirms the D.C. Court of Appeals by virtue of not taking the case. The case then goes back to Judge Chutkan. But we are waiting, Court of Appeals, for a decision by you about this immunity issue, which again then would permit Judge Chutkan to proceed with the trial at some point down the road. She plainly is not going to be able to try this case anytime soon. The March 4th date has certainly already passed. And recognize, too, that a part of that trial is going to be selection of a jury in the D.C. area. That will take presumably days, if not weeks in and of itself, in addition to the trial itself. Why do I mention all that? Just because Judge Chutkan has got to find a significant block of time in which to try this case once this immunity issue is completely resolved. We will follow up whenever the D.C. Court of Appeals issues its decision, whenever, hopefully, the Supreme Court refuses to take the case on, and this matter, this all-important matter, continues apace. Stay with us for more discussion. And we're back on our continuing discussion of courts in America, chatting right before the break about this action anticipated by the D.C. Court of Appeals on this issue of presidential immunity, having just this past week decided that Donald Trump loses when it comes to his appeal on the order restricting him, as any defendant would, from commenting about the witnesses and other participants in the judicial process. Other things going on before the Supreme Court right now, we know based upon news reporting and our discussions on this very broadcast that the Supreme Court has granted certiorari, has decided to review this all-important decision coming out of the Colorado Supreme Court. You recall all of this in recent days and weeks. The Colorado Supreme Court affirming, and actually expanding, if you will, a trial court judge's decision on whether or not Donald Trump can appear on the Republican ballot, the Republican primary ballot coming up here in March. The Colorado Supreme Court recently saying that not only did Donald Trump engage in insurrection on or about January 6th, certainly before that time, arguably even after it, affirming that fundamental finding, but significantly, that Section 3 of the 14th Amendment, which is this insurrection provision of our Constitution, that it does apply to him, that it does indeed apply to the president. And for that reason, the Colorado Supreme Court making this determination that Donald Trump's name will not appear on the ballot there in Colorado as a part of the Republican primary proceeding. No small thing. First time in our history that this particular invocation of the language of the Constitution in this way has been evoked. And as you know, Donald Trump appealing that decision to the Supreme Court. And in this case, the United States Supreme Court granting that writ of certiorari and saying, yes, indeed, we will review this argument that Donald Trump has, that the Colorado Supreme Court got it wrong, and that indeed he should, as he is arguing through his attorneys, his name should appear on the ballot there in Colorado. Last week, we talked about what's happening right now. The Supreme Court, as a part of its review, obviously asks the parties to submit briefs, written documents, the things lawyers love to write about, and then to speak about. And that is the process that's going on right now in connection with this Colorado case. It has not yet been primed for oral argument. We'll get to that in just a moment or so. But the parties are filing briefs, are arguing in written form their positions in support of and in opposition to what the Colorado Supreme Court did. Donald Trump, by virtue of being the petitioner, as you heard last week, has already submitted his brief, arguing that the Colorado Supreme Court got it wrong. And not only is there no insurrection in which Donald Trump participated, but that under the language, the intent, the purpose of the 14th Amendment, he is not subject to the prohibition of service in office, having once taken an oath of office to support and defend the Constitution and protect the country. That was his position, and we recited some versions of the text of that memorandum just last week. Just this past week, the petitioners, those people, those Colorado residents who brought this case in the first place, laid out their arguments to the Supreme Court, filing just yesterday on their petition on why Donald Trump should be barred from that state's primary ballot, contending, in fact, that his actions leading up to January 6th and on January 6th, that attack on the Capitol amounted to an insurrection, and maintaining that, yes, indeed, although we don't have a lot of, if any, interpretation of this constitutional language, that it does indeed apply to a sitting president. In the court filing, embedded with photographs of rioters attacking the Capitol, some of those photographs you've seen in the media, and actually tweets from Donald Trump, those voters in Colorado are asserting that Donald Trump spurred this wild attack on democracy, betraying his oath of office. They said this. He said, as president, Trump swore to preserve, protect, and defend the Constitution. Instead of peacefully ceding, C-E-D-I-N-G, power, Trump intentionally organized and incited a violent mob to attack the United States Capitol in a desperate effort to prevent the counting of electoral votes cast against him. That's what the Colorado petitioners in Colorado, now before the Supreme Court, have written to the Supreme Court just this past week. Now, the justices themselves have scheduled oral argument, and that's scheduled for February 8th. Mark your calendars for that. February 8th, the United States Supreme Court will entertain oral argument on these opposing positions. Between now and then, Donald Trump does indeed have an option to file a reply brief, and that is due on February 5th, just a few days before the oral argument itself. The case is called Trump versus Anderson, and it is going to be argued again on this early date in February. Happens to be just a month before, or less than a month actually, before Super Tuesday, this all-important date in the president campaign. Many states, including Colorado, are holding their primaries on that Super Tuesday. And so the timeliness, incredibly important. As we've talked before on this broadcast, one of the major issues is going to be this interplay between what's going on in the courts of America, the criminal cases, the civil cases, and the politics of America in 2024, and all of it having to do with timing. When judgments will be entered, when decisions will be rendered, when oral arguments, when briefs will be submitted, all of this going on while obviously the president, the former president, continues to petition all of us to be returned to the White House, as does the president incumbent, Joe Biden. All of this going on while that campaign proceeds. Now, as I said, Section 3 of the 14th Amendment added in the wake of the Civil War, language prohibiting from holding office those who have, having previously taken an oath, which Donald Trump did, as a member of Congress or as an officer of the United States of America. And that's the other piece of this language that the petitioners coming out of Colorado are seizing upon in their brief. They're saying, you know what, that officer reference has got to include the chief executive, the president of the United States of America. In their brief, it says Section 3 does not give a free pass to insurrectionist presidents. They are officers because they hold an office. They added this. They said it would defy common sense to hold that Section 3 disqualifies every oath-breaking insurrectionist officer down to a postmaster or a county sheriff, except the most powerful one, a former commander-in-chief, focusing heavily on the history of the amendment, describing how sparingly it's been used for over a century, as they said, because insurrection against the Constitution has been mercifully rare. All of that in the brief filed this past week. The Supreme Court taking up that issue in its oral argument on February 8th, presumably issuing a decision sometime between February 8th and hopefully before Super Tuesday, when Coloradans and others go to the polls around America in this primary process leading up to the nomination of a Republican candidate, a Democratic candidate, and plenty other candidates out there for the presidency of the United States of America. We also know that just this past week, no insignificant footnote, that coming out of Maine, you may recall well, the Secretary of State there named Shenna Bellows had previously invoked this somewhat peculiar process in Maine by which petitioners, residents can seek her certification or a lack of certification. She had previously ruled that Donald Trump could not be on the ballot there. Just this past week, Maine's top court had indicated that her appeal of the decision that required that she forego and not proceed with that, the Maine Supreme Court affirmed the lower court, telling her to wait the U.S. Supreme Court decision on this Colorado case, and so we'll continue to monitor what happens there in Maine, depending upon what happens in the Colorado matter, also pending right now before the United States Supreme Court. All of that having to do with the campaign. When we come back, one final comment about the Supreme Court before we move on. Stay with us for more of all of this.
AUK.
And we are back here on our Saturday morning broadcast. Thank you for continuing to engage with me in this discussion about courts in America. Very significant things happening throughout these past days and weeks. Right before the break, talking about what's happening right now before the Supreme Court, focusing in part upon this notion that Donald Trump has appealed the decision of the Colorado Supreme Court, keeping him off the ballot there, anticipating decision there from the Supreme Court sometime in perhaps maybe late February, but certainly well in advance of Super Tuesday. There is yet a third matter that's pending before the United States Supreme Court. The first one arguably being this immunity issue if Donald Trump chooses to appeal that and the Supreme Court chooses to take it. The third matter, however, is the one that's kind of flying under the radar these days. Not a lot of attention to it. It's a case we've talked about before. It's called Fisher. It takes its name from one of the 1,200 defendants that have been either investigated, convicted, sentenced for the riot on January 6th at our United States Capitol. Mr. Fisher challenging his conviction and his sentence on the basis that the statute under which he was charged, 18 U.S.C. Section 1915, having to do with obstruction of official proceedings. That particular statute cannot and should not apply to these particular facts having to do with the attack on the Capitol and the things that he himself did. The reason why that case, the Fisher case, Fischer, is relevant to Donald Trump is the Supreme Court has not yet scheduled oral argument on that case, so we don't know when it's going to be entertaining these arguments. But again, accepting briefs, those are already pending before the Supreme Court. In that particular Fisher case, this statute, Section 1915, Supreme Court will tell us whether or not it can be used in prosecuting people in Mr. Fisher's circumstance. And why is that important? Why is that significant to Donald Trump? Well, it's because that same statute, Section 1915, is also one of the statutes, not the exclusive statute, but one of the statutes that underpins two of the 4 charges against him in the indictment in the D.C. District Court, pending again in front of Judge Chutkan. All of these things play back against each other and into each other, all related. And if the Supreme Court makes any determination that in any way limits the applicability of Section 1915 in the Fisher case, it could have a dramatic impact upon the prosecution of Donald Trump in the district court in front of Judge Chutkan. The same statute being reviewed presumably sometime soon by the United States Supreme Court could have either an affirming effect upon that prosecution pending in front of Judge Chutkan, or it could have, frankly, a devastating impact upon it if the Supreme Court finds that Section 1915 is not applicable to the particular circumstances that Mr. Fisher provides. Question will be, does Donald Trump fall within that ambit as well? And for that reason, should the 2 counts against him in his separate but very important, top of the list important prosecution, should those counts also fall? No oral argument scheduled on that yet, but anticipating the Supreme Court will sometime soon make a determination on that Fisher case, again, in this group of cases pending or potentially pending before the Supreme Court in our times. I promised at the outset of our broadcast this morning we would turn to another major issue that we have not talked a lot about, a little bit, but not a lot about on our Saturday morning broadcast, and that is the death penalty, a grisly and dark topic, but nonetheless part of our history and part of our contemporary focus, because just in recent days, including just this past week, 3 major stories involving the imposition and elections to pursue the death penalty in the courts of America. We're going to talk about those in the remaining time that we have together this morning on our broadcast. The death penalty itself. What is the history of this concept in our nation? Well, it goes back obviously long before the 1970s, but in recent times, 1972, a case called Furman, F-U-R-M-A-N, versus Georgia, case coming out of Georgia, the Supreme Court invalidated the existing death penalty laws. Why? Because they did in fact constitute, under the 8th Amendment, cruel and unusual punishment in violation of the Constitution. Those laws resulting in a disproportionate application at that time in this Furman case of the death penalty, and specifically they were focusing on discriminating against impoverished and minority communities, finding that it is in fact under those circumstances a violation of the 8th Amendment. 4 years later, however, in the now leading case, a case called Gregg, G-R-E-G-G, again versus Georgia, 1976, the court not only refused to expand from it, basically reinstated the death penalty. It said this, that the death penalty was not per se unconstitutional. And that's a major, major decision by the Supreme Court that to this day holds, that says that the imposition of the death penalty is not unconstitutional in and of itself, and could in fact serve, according to the Supreme Court, 1976, some social purposes of retribution and deterrence. The court there specifically upheld Georgia's new capital sentencing procedures, saying in effect that the Georgia rules reduce the problem of some arbitrary applications seen in those earlier statutes that had been animating the Furman case. Now, many, many other cases since then. 1977, a case called Coker, established that a penalty must be proportional to a crime. And these are the cases that followed that basically said, yes, while the death penalty can in fact be imposed by the states if they choose to do that, still there are processes, there are standards, there are rules by which the courts need to abide. They need to follow things if, in fact, the Eighth Amendment prohibition is to be regarded and given its due. So in this Coker case, the court found that the punishment does, in fact, violate the Eighth Amendment prohibition, and that the court, in fact, has to do what's called a proportionality analysis, looking at things like the gravity, the seriousness of the offense, how the particular jurisdiction punishes other criminals, and finally, how other jurisdictions punish the same crime. All kinds of things that, again, indicate that the process by which you get to the result of the imposition of the death penalty, that is all important. And that's where the litigation takes place right now. Cases like Kennedy in 2008, another case involving Brown versus Sanders in 2006, a case called Kansas versus Marshall, also in 2006, all of them clarifying this notion of things like aggravating factors, the things that the courts and juries and trial judges and appellate courts need to be attentive to ensure that there is not cruel and unusual punishment on the imposition of the death penalty, if indeed, that is where the court, that is where the finder of fact is going to be resolving the case. That's how they're going to do it. The method of execution, also very important and significant for understanding something that happened just this past week. The court basically saying that a legislature can, in fact, prescribe the manner of execution. But again, the means by which the death penalty is imposed cannot inflict unnecessary or wanton pain upon the criminal. A case called Bays versus Rees in 2008 said that as well. It's got to be a situation where the courts will be objectively looking at the mechanism by which the death penalty is imposed. The method of execution can also violate the Eighth Amendment if that method somehow accomplishes cruel and unusual punishment, something that we're going to talk about in just a moment or so. And then the Supreme Court has also said in a series of cases involving a case called Atkins, another case called Bobby versus Buys, 2002, 2009, that there are certain categories of people who under all circumstances cannot be subject to the death penalty, cruel and unusual punishment in all cases for people who are intellectually or developmentally disabled. If in fact that is the categorization, that is the finding made by the trial court, no possibility of imposing the death penalty upon people who have an intellectual or developmental disability. And the finding that if you do that, that is indeed cruel and unusual punishment prohibited by this Atkins case in 2002. And in another case, 2005, also the death penalty prohibited for all juvenile offenders. No juvenile offenders can be subject in our federal system, our state system, to the death penalty, pointing to the lack of maturity, responsibility, greater vulnerability to negative influences, incomplete character development, all of those things related to the kinds of people who cannot, under any circumstances, be subject to the death penalty. Huge amount of litigation going on out there has always been, and in fact, there is increased attention to it in recent times, including just this past week. Let's talk about two, if not three, of those cases coming out of the news of just this past week. Again, getting back to our United States Supreme Court. On Wednesday, while it's doing all these other things we've already discussed, the Supreme Court, United States Supreme Court, and a federal appeals court just below it declined to intervene to stop the state of Alabama from conducting the nation's first ever execution by a process called nitrogen gas, in particular called nitrogen hypoxia. And it basically put the state on track to do what it did on Thursday evening, which is to put to death by nitrogen gas a defendant who's on death row. His name is Kenneth Smith. He was convicted of a 1988 murder along with other people. And that happened, this execution of him on Thursday of this week, following the state's botched attempt to execute him by lethal injection in November of 2022. And again, this case, the case involving Kenneth Smith, underscores the significance of the method by which states can and cannot impose the death penalty. The Supreme Court, in advance of the execution of Mr. Smith just a couple of days ago, finding that there's no cruel or unusual punishment prohibition under the Eighth Amendment. The Supreme Court permitting that to go ahead. Mr. Smith's lawyers had said that they feared that this newly created protocol involving a nitrogen gas was not sufficient to prevent problems that could be caused to their client, and in particular, severe suffering in the very act of putting him to death. This is grisly. The lawyers said in the court papers filed before the Supreme Court, the lower courts as well, that this particular method, the method by which Mr. Smith would be put to death and was in fact put to death on Thursday, could be compromised if the mask over him was a poor fit. It could allow oxygen into him and prolong his suffering, causing him to become nauseous, and could quite literally choke to death. Well, the execution did in fact take place. The Supreme Court again declining to intervene in that case in Alabama. And sure enough, the initial reporting, again, just hours old now, raises the question of whether or not this was a textbook execution, this new method under using this process called nitrogen hypoxia, whether this new method did in fact accomplish the death that Alabama wanted, the execution of this prisoner, this defendant, that arguably would be in compliance with the Eighth Amendment if it was not cruel and unusual, or was in fact botched once again. And this Alabama case, according to early reporting, leaves some lack of clarity on exactly what happened. Again, about a day or so, yesterday, after the execution of Mr. Smith on Thursday night, the state's attorney general, his name is Steve Marshall, called it a textbook execution. And that using this nitrogen hypoxia, said that's a proven method that other states could now emulate. He is talking, obviously, on behalf of the government, saying it was successful. No violation of the Eighth Amendment by virtue of the mechanism by which Mr. Smith was put to death on Thursday night. Meanwhile, other people who were there, some witnesses, his spiritual advisor, and others say that they witnessed an execution that included a very intense reaction. Mr. Smith apparently violently shaking, writhing as the gas was administered, heavily breathing, and finally stopped moving. Descriptions at odds with what the state had promised in court papers to the Supreme Court that had permitted this execution to go ahead, namely that the untested method, this nitrogen gas through a face mask, would rapidly lower the oxygen level in the mask, ensuring unconsciousness in seconds. Questions about whether or not the application of the death penalty here is itself now in violation of the Eighth Amendment by virtue of the mechanism, this nitrous oxide situation, nitrogen hypoxia, imposed in Alabama. And again, raising the issue of death penalty in America and the mechanisms by which states are and are not permitted to go ahead, even though, again, under the case law that I described earlier, the death penalty permitted in America, in and of itself, not a violation of the Eighth Amendment, but practices to get there, in courts, out of courts, and even the method of administration of the execution, all of that still subject to review by the courts of our land. When we come back, we're going to talk about a couple more death penalty cases in our final segment this morning on our Saturday morning broadcast. And we are back here in this, our final segment of our Saturday morning broadcast, talking about a very serious topic in our lives, the life of our nation. That is the death penalty in America. Proper, constitutional, our Supreme Court has said, under the Eighth Amendment, but nonetheless attaching to that permission to execute individuals on death row if a state chooses to do that legislatively and through the courts, nonetheless imposing upon the states and the courts obligations to ensure that they get it right in terms of the mechanisms leading up to the finding that would support an execution, and also even the very administration of the execution itself, as we saw just this past week, the Supreme Court, United States Supreme Court, in an unsigned opinion, not noting any dissents at all, the Supreme Court permitting the execution of Kenneth Smith to go ahead in Alabama, this process called nitrogen hypoxia, first time in our nation's history, imposing that on the defendant, Kenneth Smith at the time, and questions coming out of that about whether or not it was indeed properly administered, whether or not Mr. Smith, in his last moments of life, did in fact suffer some cruel and unusual punishment certainly more coming out of Alabama, arguably even the courts down the road. The same Supreme Court that permitted that execution to go ahead just this past week also decided to hear another case, agreeing on Monday of this past week to decide whether another individual, his name is Richard Glossip, Glossip, he's a death row inmate in Oklahoma. This is an Oklahoma case, deserves a new trial in light of some newly discovered evidence and, frankly, an extraordinary concession. Doesn't often happen from the state's attorney general. Glossip himself convicted in 1998 of arranging the death of his employer, the owner of a motel in Oklahoma City. And so no doubt again, that the charges were brought based upon his alleged involvement in that. Two independent investigations, however, have cast doubt on that, his involvement in that. And he has attracted support from many celebrities out there and even state lawmakers from political parties on both sides of the aisle, if you will. The state's attorney general, and this is where it gets so very interesting and atypical, his name is Gunter Drummond. Attorney General Drummond told the justices that the state, Oklahoma, had come to the difficult but essential conclusion that Glossip's capital conviction is unsustainable and a new trial now imperative. He added, the injustice of allowing a capital sentence to be carried out where the conviction was occasioned by the government's own admitted failings would be, in his words, nigh unfathomable. Indeed, it would be. Now, lawyers, we call these things confessions of error, confessions by the government, by the state, that there had been an error made in the course of the underlying litigation, the trial. And courts ordinarily give them great weight. In May of last year, after hearing from the attorney general there, the Supreme Court halted Glossip's execution while the justices consider whether to hear his appeal. And the courts, of course, look at these things, especially when an attorney general like Mr. Drummond in Oklahoma comes forward and says, we have a significant problem here. The significant problem in this particular case is that Glossip was convicted based principally on the testimony of what's so-called an indispensable witness. His name happened to be Justin Sneed. And there is significant doubt about whether or not Justin Sneed was a credible witness, whether information about his past history was presented. Prosecutors had reason to know that Sneed's testimony was false in the course of the prosecution. Despite this knowledge, the government has now said the state permitted Sneed, this testifying witness, to effectively hide some of his conditions and the reasons for some prescription medicines he was taking. That all related to the legitimacy of the ultimate conviction of Richard Glossip and placing him on death row. The Attorney General, appropriately, rule of law, an obligation in this situation to come back and say, you know what? It appears we have at minimum made a serious mistake. That's understating it dramatically. Thank goodness the execution of the defendant had not proceeded. And indeed, just this past week, the United States Supreme Court, in a fairly rare move, had decided to hear the case of this Oklahoma death row inmate, Richard Glossip, and they have decided to review this case. Interestingly, Neil Gorsuch, who had heard an aspect of the case, an appeals court judge coming out of the 10th Circuit, he's recused himself from it. So there are justices there in the Supreme Court recusing themselves when it's appropriate to do so. The order granting this cert here in this particular case instructed the lawyers to address in their briefs whether the Supreme Court had jurisdiction to review the Oklahoma court's ruling in light of the possibility that it was based entirely on state law. So there's still some jurisdictional issue, but the upshot of all of this is just this past week, the United States Supreme Court, in this case involving Richard Glossip, has effectively stayed the execution there and is going to entertain argument on all of this. And presumably is going to do that in its next term, not likely to do it in this term. Next term beginning when? The first Monday in October. And meantime, of course, Richard Glossip will not be executed while all of this is reviewed by our highest court in the land, addressing as late as 2024 issues related to the underlying predicates, the premises, the facts underlying the very prosecution, the case, the judgment against a defendant. Justice at work here. We don't know how this is going to be resolved, but again, when a government official comes forward and identifies problems in the underlying prosecution, especially when it comes to this ultimate imposition of a penalty by a government, appropriate to do so. Final comment about the death penalty, and that is an announcement made by the Attorney General of the United States of America about 2 weeks ago. You may recall well this horrific shooting, this hate crimes shooting in Buffalo by a fellow named Peyton Gendron, a 20-year-old. He had entered into this shopping mall, a white supremacist, killing 12 black people in Buffalo, New York. And just this past week or so, the Attorney General, again, in a fairly rare move, announced that the government, the Department of Justice, will be seeking the death penalty for the first time in this mass shooting in Buffalo, identifying, obviously, the factors that go forth in making that all-important decision. Now, the Attorney General has previously, the President Attorney General, as you probably well know, has previously placed a halt on all federal executions. But the Attorney General's first approval here of a new capital prosecution, again, signals sort of a new chapter, if you will, in the long and this very complicated history of the death penalty in the United States of America. Obviously, all of the trappings, the processes, the procedures that we talked about will now attend 20-year-old Peyton Gendron as that case proceeds, again, based upon the recommendation now that the government is going to be seeking the death penalty as to him for that Buffalo hate crimes mass shooting. Join us again next week for more discussion of these and other important issues in the courts of our land, the federal courts, the importance of decision-making by judges, by appellate judges, by trial judges, by prosecutors, by attorneys general, by local state prosecutors, and yes, indeed, by tribunals that are deciding issues of the rule of law in our times. Thank you for joining me this Saturday. Join us again next week for more of this discussion on our Saturday morning broadcast.